Tim, behind the camera. Happy to be with all of you this morning. I am joined on the line today by Sal Di Costanzo, an elder attorney in northern and southern Westchester, elder law attorney, and he's a recurring guest on the show. We did not have his February visit, so we wanted to get that in before the month was over. But Sal comes on discussing legal matters that are specific to the elder law realm and shows us why not just any attorney can handle these sensitive legal affairs. So good morning, Sal.
Good morning, Jen. How are you this morning?
I'm okay. I'm trying out a new seat today because you're not here and I can't get my bearings exactly, but this is a seat you get tangled up in all the time, and I can see why. The wires are a mess here.
Now you know I don't like that seat.
It's not you now. I get it. But good morning. So happy to have you on the air.
It's always a pleasure, Jen. Good morning to your audience.
Every time you come on the show, you get a phone call of somebody who heard you, or they say to me, I need to get that elder law attorney, because we really touch on topics that everybody, it passes through everybody's mind, but nobody stops and takes the time to do it and to settle these affairs. And then when they hear you, it's kind of a poignant reminder, oh my God, I got to get this done. So hopefully you're going to get some more calls after this today. But I wanted to talk about a few issues today. Time always goes really fast when we speak. I want to talk about new power of attorney forms, a couple of Medicaid forms. And I want to talk about things that, come up in my business, my line of work, that I say now's the time to get people thinking. I had an issue that you would appreciate a couple of weeks ago. I had somebody who represented herself to be a spouse, and she, in fact, was not. And she identified as a spouse. She made the arrangements and goes on a death certificate as a spouse. And then, lo and behold, she's not a spouse. So, her excuse was, well, I'm like a spouse. But it raises a very important question about successive marriages and protocols and protections that should be in place. This is something I hear commonly, Sal. People always say, does New York acknowledge common law? And it's a blatant no. But let's talk about the implication of, legal titles and what, in fact, a spouse is allowed to do versus adult children when you have that second marriage situation.
It's a very interesting topic, and it reminds me when I was at Ernst & Young as a tax attorney. Somebody had once taught me, and it was actually a case that I was working on, always to ask the questions that even might seem very benign and very basic. In this particular case, it was a tax case, and nobody thought to ask, and it wasn't on our end, just so everybody knows, but nobody thought to ask whether the person was a United States citizen. Everybody just takes it for granted that
Right.
Everybody, generally speaking, are United States citizens, and, somebody on our team actually realized that this person was not a United States citizen, really just by looking through superficial documents. And, the consequences of not asking that question could have been, very severe from an estate planning perspective. But, to your point, people assume often that just because they're in a relationship with somebody, that they have certain rights and even responsibilities. And on the flip side, the same assumption is actually made by people who are, let's say, married, who believe that they have certain entitlements, and they're wrong on that side of the equation too. For instance, when somebody comes into me, let's say a wife comes into me about her husband who is disabled and perhaps is in need of nursing home care. We want to look towards Medicaid to pay for that care. There's a process for transferring title to assets. And, this is going to lead into what we talk about later on, which is the power of attorney. But often people come to us, and the person who has the assets has lost their capacity.
Right.
Right? They might have dementia, they might have Alzheimer's. And the spouse, I can't tell you how many times I've heard this, but the spouse thinks that just because they're married, she has the right to put the house into her name.
Correct.
Or she has the right to move a bank account into her name, or she has the right to sign, beneficiary designation forms, et cetera. And that's just not true.
Right.
Each person is treated as an individual.
misconceptions, and they bypass the part where there has to be an actual transfer, an active transfer.
That's right.
You know,
And
go ahead.
if that person doesn't have capacity,
Yeah,
you
exactly.
get into a whole host of other issues. And now, on the flip side, which is sort of the situation that you just ran into, and I sort of mentioned this in January when I was on the show. There are people that have been living together for years. Let's say two men have been living together for the last 30 years and never got married, which is actually a case that I was working on in January when I came on the show. It was very important for us to sit down and talk about how just because you've been living together and been treating yourselves as a married couple doesn't mean that you're afforded the same rights as a married couple in New York State.
Correct. The courts are not going to recognize a legal relationship where none exists. So, regardless of how you're holding yourself out to be, the legalities still need to be in place for recognition.
That's right. And so both sides of the equation require intimate planning.
Correct.
If you're not in a marriage, things need to be done, and we talked about this last time, like powers of attorney, healthcare proxies. More importantly, and this probably would be something that you would see on a regular basis, but the disposition of your burial remains, you should put that on paper. In this particular case that I was working on, these two gentlemen just thought that they were going to make decisions for each other regarding burial arrangements, and that's not true, right? That's not true.
Absolutely.
So we filled out a burial remains form, so that way they could appoint each other to make these decisions.
Yes, the agent letter. And I think, these issues come up now so commonly because we always talk about this, like the family unit is somewhat dissipated and there's all these new norms. There are, substantial number of peoples who cohabitate. And then I think when you get into to the generation of people who were married once and divorced or and they go again and do it a second time, they don't, they want the companionship. They don't necessarily want the legal arrangement. And, they think it gets messy sometimes with legality. So they cohabitate and it's a mutual decision, and it's not to knock the decision, but here are the implications of that, because that cohabitation is not sufficient, again, to carry legal weight. And then in the situation I was describing, when you throw adult children into this mix, it gets very messy. So the point of it all is not don't live with the one you love or don't be with the one you love, but make a plan, have clearly defined boundaries and directives and communication. It's just so important, Sal.
It's very important. And you bring up the topic of a second marriage. You bring up the topic of, living post-divorce or post-death. Those are some of the most difficult cases that I deal with in my office.
I'm sure.
They raise a whole host of issues, and I can share examples with you. Those cases really necessitate sitting down with an elder law attorney. And I got to tell you, sometimes I'm not able to easily solve the problem. I generally hold myself out as somebody that can always solve the problem. But when you enter mixed family arrangements and children not of the common, relationship today, you have multiple, people coming in, and you really only have one or possibly two clients, but you're gonna have to deal with the relationship with the children of those clients, and it gets really, really messy.
And you can see what happens. And again, not to knock the situations. I mean, I myself am entering a situation like that. So life happens, life goes on, and it's a great thing. But communication is just key. And I can understand how if it's not done properly, by the time it gets to you, it can just open this Pandora's box of issues. So when we have you on the show, we always advocate planning. And we hope that this message resonates with people who are in their 40s and 50s and are thriving and happy and healthy, because those are the people who need you the most. Because, having things in place, if you don't have things in place, you're going to be reacting and making decisions in crisis mode, and you're not making the best decisions there. Sal, you touched on this when we were talking about the non-married parties. Just an example of somebody who might be in need of a power of attorney. Obviously, powers of attorney stretch far beyond those scenarios. Talk about who needs a power of attorney, why do you need a power of attorney, And what are the new forms that New York is recognizing?
Well, Jen, the first couple of questions you asked me are very easy. Everybody needs a power of attorney. It's it's unfortunate, and we keep bringing up this pandemic, but I've had some terrible, terrible experiences over the last year with young families, who are, developed, COVID, and couldn't make their own decisions regarding their finances. I know stories, clients of mine, where young people have died. So everybody needs to sit down and do their planning. After going through what we've gone through this last year, and again, my sympathies to everybody that's lost a loved one. I lost a loved one. You've got to be out of your gourd not to sit down and do your estate planning at this point. You really have to be out of your gourd not to sit down and do your estate planning. The things that I have seen, I lecture about this all the time, and so do you, Jen. And we tell people, you have to do your planning. You have to do your planning. You got to do it. You're never too young. You're never too old. And, a lot of people just don't listen, right? A lot of people say, I'm going to do it, I'm going to do it, I'm going to do it, but they never get around to doing it.
Right.
Well,
right.
If after what we saw this year does not act as an impetus for you to get out there and do your planning, I don't know what will.
Well, all the what ifs have happened. The worst case scenarios have happened. We've recognized the worst case, or all the what ifs,
or all
the things we thought would never happen have.
Everything.
Exactly.
I've seen it all this year. There's all the cases that we always talk about have all happened this year in some way, shape, or form. But that's not really what we want to talk about now. The power of attorney is part of a typical estate plan, right? So anybody that comes into my office, one of the first things that we do is look at your power of attorney. A lot of people have powers of attorney, but they're deficient in drafting, right? They don't have the right modifications. They weren't done correctly under the statute. And so we look at these. The very first thing that we do is we look at your power of attorney. And to the surprise of many, we're often redoing powers of attorney. Without a good power of attorney, whoever it is that you nominated to or appointed to handle your financial affairs may not be able to do so, right? If there's no power of attorney, we're going to end up going to court, and we're going to commence a guardianship proceeding. If there is a power of attorney and sufficient, that's great. If it's deficient in drafting, we're going to end up at a guardianship probably as well, right? So you really got to make sure the power of attorney is not something that you just go to the store and pull off the shelf like you used to do in the old days, grab a Bloomberg form and fill it out. And
Correct.
Unfortunately, there are a lot of attorneys out there that do just print out the generic form and they sign your name to it. That is not good enough. That's not good enough.
Sal, can you spell out and assign specific duties to a power of attorney, or is it just kind of an all-encompassing, right that you're bestowed?
The power of attorney form starts off as a generic form that has a bunch of boilerplate standard statutory powers. But a properly drafted power of attorney is modified by somebody like me, and we add a whole host of powers that you wouldn't find in the statute or that are limited by statute. So, for instance, we talk about Medicaid planning all the time. We talked before about a spouse wanting to move the assets to herself if her husband needed nursing home care. In order to do that, you've got to have a power in the power of attorney. You have to actually have multiple powers. You need to have one power that says that she can make unlimited gifts of her husband's assets. Unlimited gifts, not just gifts limited to a certain amount, not gifts limited to the lifetime exclusion or the annual exclusion for gift tax purposes. Unlimited gifts. So that's number one, and that's usually the biggest thing that's missing from a power of attorney. The second is case law says that if the agent wants to move assets to herself, the power of attorney has to specifically allow the agent to move assets to herself. So if you don't have that modification there that says Mrs. Jones can make gifts of my assets to herself, then we've got to look for somebody else for Mrs. Jones to make gifts to. And you can imagine what kind of problems that would create, especially like we talked about before in a second marriage.
Absolutely. So it shows you, again, not just the generic form, not just the legal Zoom form. You need somebody who's going through this with a fine-tooth comb, and also looking at every client you have has a different set of circumstances. They're going to require different types of specified planning. So just begs the need for a specialist. And I always say, you don't go to your internist, when you have cardiac issues. You need to go to the specialist. And this is a classic example. You could stand to, you want to preserve wealth. You want to preserve what you worked your lifetime to achieve. And you do want to be able to pass it down to family, but you need to do it in the proper channels. So powers of attorney are so important. And these are not to be confused with healthcare directives. Correct, Sal?
That's right. That's right. The healthcare directive is for your healthcare needs, and the power of attorneys for your financial needs.
But it all comes under the umbrella of planning ahead.
That's right. That's right.
So, Sal, you touched upon, COVID and how it, it begs the need for planning, and it should make everybody stop and take a moment and be introspective and say, this is what we need to do. There was so much that we've seen over the past year in terms of electronic signatures, remote document execution. Talk a bit about how COVID has changed the legal planning realm, and what changes do you think are in fact here to stay? I mean, you have people, over FaceTime probably executing last wishes, I would assume. Let's talk about the legalities of this virtual world that we're living in.
Well, that's a good topic. Before we talk about that, you asked, what are some of the changes that have happened and are coming on
yes,
the forefront.
The power of attorney. Yes.
Yeah.
All right,
let's
back
make
it up.
sure everybody. Yeah, this is a big one. So I'm going to be lecturing for one of the title companies on this in a couple of weeks. In December, Governor Cuomo signed new legislation changing the general obligations law, which is the law that governs the power of attorney. And without getting into too many details, if any of our listeners have any experience signing a power of attorney, you know that the power of attorney form is pretty voluminous. It's multiple pages. There's a lot of places that need to be signed and initialed. There are formalities that need to be followed, and there's this thing called the statutory gifts rider, which I think it's about 10 years old and people still don't know what it is. And so you can imagine, Jen, and this also plays into, some of the remote signings that we've done last year. I can tell you some of my experiences with that, and we're still doing. I have to do a remote signing today, actually. You can imagine how difficult it is to have a power of attorney signed in a nursing home setting, especially if it's remotely.
Correct.
Right?
Mm-hmm.
We show up into pre-pandemic, we would show up at a nursing home and sit there with the client and have the client initial, and they would initial like one or two boxes, and they're tired, they're laying in a bed.
Mm-hmm.
It's a horrendous experience with these powers of attorney. So to make a long story short, they've simplified the power of attorney, or so they say, right? Like every time somebody tells me that they pass a law that simplifies something, I laugh, and I chuckle, and I'm like, yeah, right. When Trump, passed new legislation a couple of years ago and supposedly simplified the tax return, I think many accountants would agree that the tax return is more complicated now than it's ever been before, even from an optics perspective. So the power of attorney is now simplified. The new law does not go into effect until June 13th.
Okay.
So you don't have to get nervous just yet. But after June 13th, you need to be mindful of the fact that if you draft a power of attorney, it's got to be drafted under the new law. And this is what happened back in 2009 when the power of attorney statute was changed back then to introduce the statutory gifts rider, right? So they gave it to us in 2009. Now they're taking it away in 2021. It wasn't until, quite frankly, a couple of years after the enactment of the new law that you would religiously start to see the new form being used. So many attorneys, especially places like banks, especially, and this goes to your point before about using somebody that focuses in this area on a regular basis. If you're an attorney that does a little bit of something every day, so maybe today you drafted a will and tomorrow you do a real estate closing and the next day you're doing something else, you may not know, number one, that the power of attorney statute changed, but even if you do know, you may not have the new forms. So you might be going into your forms database printing old powers of attorney that are invalid after June 13th. And I saw that happen all the time in 2009. So
Sal, the people who had, prior to June of this year, anybody who has a power of attorney document executed, does it have to be redone, or is there
it does
grandfather
not.
protection?
It does not. That's always been a big question, even with the old form. But what happens, Jen? And this is my honest advice. Anytime there's a change in a form, even though the statute doesn't require that you go out there and change your power of attorney,
Mm-hmm.
you know, over time, that new form is going to be the prevalent form out there. From a business perspective, from a banking perspective, and you're just going to probably want to redo your power of
Exactly.
attorney just to conform with current trends.
And it's a good idea too. We always advise this, you and I, every couple of years, to take a look at your planning documents and your legal documents, and just do some administrative housekeeping. So it's a good idea anyway, I think. But you're right. If it's new and you know about it, why not just execute it on the new updated form?
That's right. So now, for people that are somewhat sensitive still about coming out to do their estate planning documents,
Mm-hmm.
Everybody's getting vaccine now.
Yeah.
The trend is on a downward, slope as far as infection rates go. But I still understand that people, are kind of hanging low still until they're fully vaccinated, or maybe they've gotten the first vaccine and they're waiting for the second vaccine. We can still draft your documents and attend to the signing of those documents through remote procedures, right? So this is what you asked me about before.
Yes.
Last year, Governor Cuomo signed an executive order, which has been being extended, allowing us to get onto a Zoom and go through certain procedures to sign a will, a power of attorney, a healthcare proxy. So that way it's just as valid as if you were sitting in my office.
Okay.
This works. We've done a lot of them. I will tell you, it is somewhat cumbersome. It's a somewhat cumbersome process.
Sure, I can
because
imagine.
it requires that the client scan us back the documents that they signed that day. And this is a problem for like our elderly clients, right? So, and then of course, as attorneys, if this executive order was signed in the middle of a pandemic. So in my opinion, it could have been flushed out a little bit better. And so when you get an attorney saying, well, what does this really mean? Could we do this? What if we did this? For instance, the executive order says that the client has to send back by electronic means the document the same day. So I said to myself, okay, that's fine. But what if I just have the client drop the document off in my office? They're not coming into the office. They're just stopping, by the front of the office, dropping the document off. You would think that would make sense, right?
Well,
we don't
no,
know.
in New York State, I wouldn't, but it does make sense. But we're in New York, so I would assume there's some loophole here. No, there's a lot of ambiguity. There wasn't a lot of we were all learning trial by fire. So, we're coming to the close of our time, and I want to be able to give your contact information, but I think this would be a great topic for the next time that you're on. Sal, you just kind of show us here your breadth of knowledge, and everyone listening and watching today, we hope that you're taking away. You have to make a plan. Even when you don't think you have to, that's the time when you have to make a plan. Sal, you really do a great job in outlining all the what ifs. So I want people to know where to find you and how to listen to your upcoming lectures if possible. You have a website with your blog. What is the website?
So first, I'd just like to thank everybody who has called me, because I have gotten a bunch of phone calls after every time I come on your show. So thank you, and I encourage you to continue to do so. But my website is www.plantodayfortomorrow, all spelled out one big word. Plan today for tomorrow.
And that's exactly what we need to do. Plan today for tomorrow. You have offices in northern and southern Westchester. What are your phone numbers?
That's right. We're in Rye and Yorktown Heights, and the phone number is 914-925-1010. And we'll be happy to speak with you if you call up.
And the lectures that you do, you usually post an article on your website. It's pretty up to date. They can, you write frequently on all these topics, and you speak extensively, even through Zoom, I imagine, or virtually. You're still doing these lectures, correct?
I do. We try to get one Facebook chat live meeting, a month. It's not always easy to plan. I try to write, one or two things a month, but again, it's not always that easy. But if anybody has any topics that they'd like to hear about, send them over.
Absolutely. Check out plantodayfortomorrow.com, 914-925-1010. Thank you, Sal. We'll talk to you in a few weeks.
Thanks, Jen.
And this is Jen Graziano thanking you for taking the time to listen as we took the time to talk. Have a great day, Westchester. Bye-bye.